Hi friend, welcome to the income tax case law update. Today we are discussing latest case law held in the matter of the Infosys Limited versus DCIT ITAT Bangalore dated 11th April 2022. In this case, it is held that the provision of the DTAA of right section 206AA of the Income Tax Act. As per section 206AA of the Income Tax Act, that is the requirement to the furnish PAN number. This section is overriding on other provision of the income tax law, where deductee shall not furnish a PAN number. In absence of the PAN number, the deductor shall deduct tax at the higher of the rate, that rate specified in the relevant provision of the act, or rate in force, or at the rate of 20%. So in this case, this is the held that DTA provision, which is a overriding effect on other section of the income tax, that is a conflicting on the DTA and or section 206AA. But if you see the subsection 7 of section 206AA of the Income Tax Act, that is mentioned that the provision of section 206AA of the income tax shall not apply on non-resident being individual or to foreign company in respect of payment of interest on long-term bond or any other payment subject to such condition as may be prescribed. Here in this case, the relevant ground with regard to the issue whether the provision of the DTA override section 206AA of the Income Tax Act is examined. Here appellant grounds that CIT appellant authority has erred in concluding that the said payment are liable for TDS at the rate of 20% as per the section 206AA of the Income Tax Act, and also not appreciating that overseas subsidy was not required to obtain PAN under the provision of Income Tax Act, and consequently there was no requirement to furnish his PAN under section 206AA. And section 206AA does not override the double taxation avoidance agreement or section 90 of the Income Tax Act, or in any case TDS rate as per the section 206AA cannot exceed the rate at which the income is chargeable to tax in the hands of the non-resident. In any case and without prejudice, despite having called for and obtained the PAN of the overseas subsidy during the appellant proceeding, the learned CIT appeal erred in concluding that the impugned payment were liable to TDS at the rate of the 20% under section 206AA of the Income Tax Act 1961. These grounds are considered by the Tribunal, and a special bench of the Tribunal, here is the reference of the case law, other case law. The special bench of the Tribunal in the case of the Nagarjuna Fertilizers and Chemicals Limited versus ACIT in 2017 had held if rate of the tax applicable under the DTAA is lower than 20% tax rate as prescribed under section 206AA of the Income Tax Act, TDS has to be deducted as such a lower rate even if non-resident deductee fails to furnish its PAN number. Further, Hon'ble Delhi High Court in the case of the Danisco India Private Limited versus Union of India reported, this case is held in 2018, that a provision of DTA overrides section 206AA of the Income Tax Act. In view of the above cited judicial pronouncement, the ITAT Bangalore held that we hold that the applicable TDS on the subcontracting charges paid to the Infosys China should be considered at 10% as per the India-China DTAA instead of 20% as per section 206AA of the Income Tax Act. It is also to be noted that while passing the order under section 201 subsection 1 and 201 subsection 1A of the Income Tax Act for the assessment year 2012-13, the assessing officer has calculated TDS liability at 10% as per the India-China DTAA. That means a provision of section DTAA override section 206 of the Income Tax Act. Thank you so much for watching this update.